Did the big beautiful bill just blow up your estate plan? Many people are wondering whether the sweeping tax law means they need to start from scratch. The short answer, maybe, and here's why it matters for your family and your future. Hi, I'm Mitch Green. I'm an estate planning attorney and asset protection attorney here in Florida. I've been helping families for decades make sense of complicated tax laws and build plans that actually protect what they've worked so hard for. Today, we're breaking down how the new federal tax law signed on July 4, 2025 could impact your estate plan. Stick with me, because if you think these tax laws only affect billionaires, there are important changes you need to understand. And if you find this helpful, don't forget to like this video, subscribe, and share it with someone who's been putting off updating their estate plan. Let's start with the big headlines. Tax exemptions. Right now, the federal estate, gift, and generation skipping tax transfer exemptions sit at $13.99 million per person. But as of January 1, 2026, that number jumps to $15 million per person, or $30 million for married couples. That's huge, because without this new tax law, those exemptions were already scheduled to drop almost in half when the 2017 tax cuts expired. What does that mean for you? If you're someone with a very high net worth, the changes probably don't alter your planning strategy much. You are already in planning mode. But for families with smaller estates, the increased exemptions free you up to focus on other areas, like minimizing income taxes and making sure your estate passes smoothly. Next, the SALT deductions, the cap on state and local tax deductions. The new law bumps that cap to $40,000 for joint filers and $20,000 for single filers for 2025. That's a big jump from the $10,000 cap we've been living with, although it does eventually revert back to the existing limits in 2030. But watch out, if your income is high, that cap starts to phase out. Now here's what didn't change. The estate tax rate itself stays at 40%. Basis step-up rules still in place. That means that property included in someone's estate gets revalued as of the date of death, a huge advantage for heirs. Portability also remains, meaning a surviving spouse can use their deceased spouse unused exemption. And the income tax brackets, the lower rates from the 2017 Tax Cuts and Jobs Act are now permanent, with the top rate staying at 37% instead of going back up. There are also new rules on charitable giving. For the first time, there's a flat charitable deduction for standard filers, $1,000 for singles and $2,000 for couples. But if you itemize, you can't claim any charitable deductions until your contributions exceed 0.5% of your adjusted gross income. That makes charitable bunching strategies more important than ever. So, are these changes permanent? Technically, yes. This bill does not have a sunset date built in. However, remember, tax laws are subject to political influence, and a future Congress could repeal or rewrite them depending upon who is then in office. That's why staying up to date is key. The clients who stay proactive, those who revisit their plan every few years, and especially after big legislation such as this, are the ones who avoid surprises and keep their families protected. So, do you need to completely redo your estate plan after the big beautiful bill? Not necessarily, but you do need to review it and probably make adjustments so you're not missing opportunities or exposing yourself to risks. That's what I help my clients with every day, crafting smart, up-to-date estate and asset protection plans that reflect the current law, not last year's headlines. If you're in Florida and you want to clarify how these changes affect you, please call my office. Let's sit down and make sure your plan is working for you and your family and not against you. Thanks for watching. Don't forget to subscribe, and I'll see you in the next video.